Strata Bites, your Strata update, with Frank Higginson from Redchip Strata Law.
One of the problems we get as lawyers is when clients engage us too late in the process. So in a body corporate context, what normally happens when you've got an issue is that it gestates over a period of time, and particularly around things like general meetings. If there's a dispute in relation to what happened or is going to happen at a general meeting, you've got at least 21 days notice before the meeting about the issue, or you've got an extended period of 3 months after the meeting to bring whatever proceeding you actually need to bring to contest what happened. One of the problems for us, and this has been highlighted in a recent adjudication, one of which is one of many, is that when you don't get on the front foot quickly enough, you can actually lose what would have otherwise been a winnable case. And in this particular example, which we'll hyperlink in this article after this, is a body corporate that knew there were issues with respect to what was being proposed. It was about the renovation of common property, so there were questions about spending limits, there were questions about the type of resolution which was put to the meeting, whether it needed to be an ordinary resolution because it was maintenance, or whether it needed to be a special resolution because it was improvements, and all of these things were well and truly on that agenda. Unfortunately, what happened here is that the motions were passed, potentially by the wrong level of authority, and the body corporate committee immediately signed the contracts which those motions authorised. And when the owners who contested that went to do so in the Commissioner's office seeking an interim order to do so to stop this going any further, the adjudicator denied that on the basis that the contracts had been signed. So at that stage, the adjudicator had to balance what was technically correct versus what were the commercial consequences for the body corporate if it potentially stopped or put the body corporate in breach of the contract that it had signed. So the lesson for me in this one is that there was plenty of time there to stop the committee doing what it is that you didn't want them to do, and you could have done that well and truly before the meeting itself. So in these things, when you've got doubts about what's happening, you need to move quickly. Now it is back to the old John Howard phrase of be alert, not alarmed. Know what's going on, and if you need to take legal steps, make sure you do them as soon as you practically can, because otherwise you might lose some rights.